And it's a very good morning from me, John Fradgley, back with you for another program of The Law and You here on 4CRB this Tuesday morning. It's your opportunity to get free legal advice between now and 9:30, that's 10:30 Tweed Coast time. All we need you to do is get on that phone as soon as you possibly can. 5520 8888 is that number again, 5520 8888. Don't forget, if you're south of the Tweed River, you need to put 07 in front of the number, or you can send questions through to talkback@4crb.com, which we will be able to deal with next week. And following on the very positive feedback we had from his last appearance on The Law and You some weeks ago, I'm very pleased to welcome back into the studios today my colleague Dan O'Connor. Welcome, Dan. Great to have you back with us.
Good morning, John. Good morning, listeners.
And Dan, today you've chosen the topic of blended families as something we're going to talk about. Certainly a very interesting area, and I know we often say in the office that these days the incidence of blended families is just so frequent in the work we're doing in the estate planning sphere. So, great topic to choose. Can you tell us a little bit about what's going on?
Yeah, so blended families obviously present a lot of challenges above and beyond estate planning, but certainly from an estate planning perspective, the issue that tends to be something that needs to be discussed is the fact that the surviving spouse has the capacity to change their will. And in many instances, that's not such a concern because the ultimate beneficiaries are the children of that one marriage. But when you've got children from previous relationships coming from both sides, we want to make sure that there's not going to be one side being treated differently ultimately because the survivor has a change of heart after the fact.
Yes, well, and how often have we seen that, Dan, where, the couple come in and see us and blended family and no, everything's honky-dory and, no, we'll definitely leave the estate equally to all the children or whatever proportions they are, and within weeks or sometimes months of the passing of the first of them to go, there's a little knock on the door and a surprise, the surviving spouse is wanting to change their will to either totally exclude the children of their deceased partner or alternatively substantially reduce their share.
Yeah, that's right.
So, Dan, it's obviously a problem, and it's becoming a bigger issue because we're seeing, because people are living longer and they're suffering from loneliness in the event of the passing of their first partner. We're seeing more and more these instances of people remarrying or just repartnering, resulting in these blended families. So what are some of the options that couples can have if they're going to be in this sort of a scenario?
Yeah, so just before I start on that, I just wanted to also mention that these strategies are of relevance to people who don't have children as well, because often there's quite a substantial number of marriages which don't result in children, and they may wish to provide for their respective sides of the family ultimately. So it has application in that sphere as well.
Well, that's certainly a very valid point, isn't it? Because we do see instances, and I know I've got one at the moment, where a couple have come in to see me in relation to their estate planning. It's a second marriage for both of them, and interestingly, neither of them have children of the first marriage, and so the issue is the nieces and nephews, perhaps, of the previous relationship that are relevant in that situation.
Yeah, that's right. That's very common.
Well, look, we've got a caller online, so we'll just take this call and we'll return to our topic in a moment. Good morning, Carol. How are you today?
Oh, good morning, John. I'm asking you about a will.
Sure.
My mother turned 99 last November.
Congratulations to her.
Yes, and she passed away on Valentine's Day of this year.
Oh, dear, I'm sorry to hear that.
Yes. So my brother is, the top executive and power and or whatever. Mm-hmm. Now, my eldest sister is next of kin. Can she not witness, but have a look at the will? My brother says no, It's all in his hands, but he's going to... We haven't had a funeral. My mother didn't want a funeral, so we haven't got closure. And he wants to have a celebration of her birth and death on her birthday in November when she was going to turn 100.
Right.
Now, we're all up in the air about this because it's just too long to wait for closure.
Yep.
And it's going to bring it all back again, but
Yes.
he's got the power to do that.
Carol, where did your mother live when she passed away? In
New
Queensland
South
or
Wales.
New South Wales? New South Wales. Yes.
Sydney, yes.
Yep. Okay. Well, look, certainly under the law of Queensland and under the law of New South Wales, beneficiaries of the will are entitled to see a copy of the will, and in particular, the children of the deceased are entitled to a copy of the will. So your brother is not correct in saying that no one's entitled to see the will. You most certainly are, and I just can't quote chapter and verse on the section of the relevant legislation in New South Wales, but certainly in Queensland it exists, and I'm sure it is the same in New South Wales. So what you each need to do is to, particularly if one of you is on good terms with your brother, it might be worthwhile one of you ringing and just saying, look, I just wanted to point out to you that there is in fact an obligation at law to provide a copy of the will to each of Mum's kids. And I think everyone would like a copy. In terms of the fact that there was no funeral, well, the arrangement of the funeral is the province of the executor, but there is certainly nothing to stop you from organising some sort of a memorial service much earlier than that, whether it is with the blessing of your brother or not.
Yes, well, that's what we're going to do. But my sister has already... My mother died on Valentine's Day, which was on a Friday.
Yes.
And she rang the solicitor to tell the solicitor that my mother had died. And the solicitor rang my brother, and then all the blah-blah hit the fan. Because my sister went over my brother and told the solicitor. Then she said, well, we need a copy of the will. And he said, well, you're not going to get a copy of the will.
Well, as I say, she is entitled to that at law. So, and normally what can happen there is that your sister could write a letter to your brother and say, look, if you don't provide a copy of the will, I'm going to bring an application to the court to get a copy of the will, and I'll be seeking an order for costs against you for failing to provide it. And I think if he speaks to his solicitor, the solicitor would point out that he's not entitled to withhold a copy of the will.
Oh, okay, okay. And my mother still got her house, okay, because she was in the nursing home or the care for 3.5 years. So she's still got her house, which is worth, say, about 900 to 100,000.
Yep.
Now, does the house have to be sold and that money split each way? Or,
well, it depends on the terms of the will. So that's why you need a copy of the will. So your mother wasn't survived by her husband?
No, Dad.
Okay, so the house needs to be sold and settled so that the payment can be made. There might be some tax issues to be looked at there in terms of the fact that she's been out of the home for 3.5 years, so that might need to be looked at. But no, that certainly is the case. You anything to add to that, Dan? Or
I know the section in Queensland is section 33Z.
Yeah.
I'm not sure the analogous section in New South Wales, but it's very similar.
Yes. No, that's right.
But you have to pay the reasonable cost for them to provide the copy of the will, so postage or something like that.
Postage and photocopying.
Yep.
But my sister can't go direct to the solicitor?
Well, I think she has to make the request via the executor, but there's no reason why she can't write to the solicitor. Assuming that solicitor has been appointed by your brother to handle the estate, then that would be the better point to write to, because the solicitor would know the law and would be able to tell your brother that he's legally obliged to do it. But we'll need to leave it there, Carol. Unfortunately, we've got another caller online.
Thank you very much,
No trouble
John.
at all, Carol.
Thank you.
All the very best.
Bye-bye.
Time on 4CRB. It's just coming up to 15 and a half minutes past 9. That's, of course, past 10 on the Tweed. As we say, a very good morning to Ruth. G'day, Ruth. How are you today?
Good morning. I'm very well, thank you. And you?
Very well indeed. Thanks. How can we help?
It's just a very quick question. My daughter lives in Sydney, and she has 3 children. Her husband walked out on her and the boys 3 weeks before Christmas in 2018. Now, they have been to the lawyer, and they drew up a proposal and some orders, which he was supposed to sign early February.
Mm-hmm.
Well, the day he was supposed to sign, he refused.
Mm-hmm.
But up until now, he has been putting his salary into the account and paying mortgage and everything, so she has had money. Now, last week, he turned around and said, I'm not paying my salary in anymore. Now, she hasn't really worked for 12 years now. She's got a job that earns like $3,000 a month, which is nothing, not going to get her very far. So she contacted a lawyer and said, you know, if he doesn't pay anything anymore, what are my rights? And she said, well, he hasn't signed any agreement, so he doesn't have to pay anything.
Well,
is this right?
Well, your daughter does have rights, though. I mean, she can bring an urgent application to the court to get orders for provision to be made. And I think from memory, and you need to bear in mind that family law is not my area of expertise, but from memory, I think that provision payments, or maintenance payments as we used to call them, are now collected by the Australian Taxation Office once orders are made. So, no, she certainly does have rights. What she needs to do is get on to a lawyer who deals in the area of family law.
Well, she does. A lawyer does, but that's what she does.
Yeah, well, I mean, she certainly doesn't have any immediate rights if he hasn't signed an agreement, but she certainly does have the right to bring an application before the court to have maintenance provided and to have a property settlement. And it may be that that the agreement that has been prepared but has gone unsigned might be the basis for that application. But she needs to move quickly, and certainly without orders, then for the moment, yes, no, that's quite right. So she might be also advised to speak to Centrelink about what support she might be able to get from there as well.
So if a lawyer says he doesn't have to pay, who does she go to help her lodge this application?
Well, it would be a lawyer who deals in that area of law. But, I mean, what it appears to me the lawyer has told her is that the agreement that she had that has not been signed can't presently be enforced because it doesn't have a signature to it to make it an enforceable agreement. So she needs to bring an application to the court to get orders that are the equivalent of what was in that agreement.
Okay. So she, okay.
So, look, if the lawyer's not being very helpful, she's better to ring the New South Wales Law Society and ask for a recommendation for a family lawyer nearby, or alternatively to ask initially for whether there is a free legal service near to where she lives, where she can go along and get some preliminary advice. Here on the Gold Coast, we've got a couple of very good services that are available. There's the Gold Coast Community Legal and Advice Bureau, and there's also another service down at Robina as well, called My Community Legal, which was previously the Robina Community Legal Centre. I'm sure there are services like that would be available in Sydney that she could take advantage of.
Thank you very much for your help.
All right then.
Thank you.
Okay then.
Bye-bye.
All the very best. Time on 4CRB, 19 and a half minutes past 9, and we say a very good morning to Teddy. G'day, Teddy. How are you today?
Good morning, I'm alive. My problem is I could not find my solicitor because when I rang the landline, it had been disconnected. So I went to the office and the new occupant said he's not there anymore. Mm-hmm. So how do I get my documents?
Dan.
So do they hold original documents for you, such as your will or power of attorney?
Yeah, but the will and the lease of my parents. Yeah.
Well, what I'd do is I'd contact the Queensland Law Society and make an inquiry with them.
See, my property is in New South Wales.
But was
And
the
I'm
solicitor in Queensland or New South Wales, Teddy?
It's Queensland.
Queensland. Okay, so you need to contact the Queensland Law Society.
Yeah, they'd hold packets for firms that are no longer, for example, if a firm had been put into administration or liquidated, a lot of those security packets end up with the Queensland Law Society, and they'd have that on their record.
What's the number, please?
I'm just having a quick look for that. Where's the Law Society gone? Oh, right, back one page. So the number for the Queensland Law Society is 1300
1300
367
367
757.
757. I repeat, 1300 367 757.
That's correct. Give them a call, Teddy, and they'll certainly be able to help you.
Good, thank you very much. God bless you.
Okay then, all the very best.
Thank you, Teddy.
Cheers now. So, we're at 21 and a half minutes past 9. We'll be back after this word from our sponsor.
With 4 beautiful locations across the Tweed and Gold Coast, Mackenzie offers the best in permanent and respite aged care. Call 1300 899 222 or visit mackenzieacg.com to book a tour.
Harvey Norman South Tweed deliver anywhere and they guarantee to beat any genuine competitor's price. And if you want good old-fashioned service, then Harvey Norman South Tweed is the place to shop. Their specialised staff will give you the best advice for your needs. With a great range of computers, furniture, bedding and electrical, there is no need for you to shop anywhere else. Why don't you go and see the friendly staff at Harvey Norman South Tweed? Because customer service is their priority.
Another sponsor.
So, Dan, we were talking about what options couples in blended families might have to ensure that their wishes are carried out. What are some of the options that might be available for them?
So the first option that I would usually mention with some clients is what's called a mutual wills agreement. It's effectively a contract between the husband and wife whereby they agree that should one of them pass away, the survivor will not change their will. So it's a way of providing surety that the situation where your children get excluded won't arise. So that agreement can be in all number of forms and it can be varied at any point in time while the husband and wife or the parties to the relationship have capacity and while they're both alive. And generally speaking, when they both pass away, when one of them passes away, the agreement's locked in place. So I suggest to clients that you need to take extreme caution with these sorts of agreements because they can be extremely inflexible if they're not drafted appropriately.
And there are also some ways that they can be circumvented too. For example, disposing of assets during a lifetime after one party's passed away.
That's right. And you need to find that balance because if there's no restriction on them dealing with the assets, they can gift them away or use them to exhaustion. But also you don't want to be limiting them to be able to not actually deal with their assets at all because we've certainly had cases where that's occurred in the past as well.
Yes. One of the things I did in a mutual wills agreement a while back was I put a provision in it which provided that after the death of either party that the mutual wills agreement could be varied with the consent of the executors of the deceased's will so that to try and remove a little bit of that inflexibility from it.
Yeah, if it's drafted with something like that built in, I find that it can actually be a very useful very useful tool, sorry. But yeah, it all depends on the parties. It all depends on who's involved, who are the executors. Is that the best choice? Maybe the parties who have the adverse interests are the ones we should be asking for consent, so the stepchildren, for instance. Because there's very good reason why you might want to change a will at some point. For instance, there might be one of the children going through bankruptcy. So rather than leaving that share directly to that child, we might want to leave it in a testamentary trust in order to try and protect it against that risk. So it's sort of a win-win type arrangement. There's nothing sinister going on there. So there is a reason why we might consent to that sort of change.
One of the things I think that couples in this situation need to give serious consideration to also is to ensure that they keep separate those assets that they want to ultimately go to the benefit of their children, for example, or their relatives, rather than to the other party's relatives, because if they own assets, if they end up with joint bank accounts and a house that's joint tenants, well, it's all going to go to the survivor anyway. So it is very important for them to think about that early on, isn't it, that they keep those assets separate.
Absolutely. The paramount discussion is to be had around what the assets are and how they're held, because all of that can completely override what the will says.
Yes.
You can try to set up a right to reside, a life interest, a testamentary trust, all these sorts of things, and if it's owned as joint tenants, that's just not going to be effective.
Now, you've mentioned a right to reside or a life interest. Often the house is the biggest asset that any couple have, and sometimes in these relationships the house will be in the name of one of the parties rather than in both names, and so how can a right to reside or a life interest be used there?
So this is a particularly popular option, I find, because it's a way of ensuring that your spouse is not going to be out of a home after one of you passes away, but also ensuring that the ultimate benefit of that asset goes to where you want it to go. So you effectively say, rather than leaving the asset to the survivor absolutely, so that it'll follow their will ultimately, you give them a right to live in the property. It can be for the rest of their life, and once they pass away, then it follows what we provided for in your will.
And you can even have transportability in that too, can't you? Because the life interest provision can provide that the property can be sold to pay a RAD, a residential accommodation deposit in a nursing home, but provisions put in there to make sure that the RAD can in fact come back to the estate of the person who's passed away.
Yeah, that's crucial because, as you know, RADs are paid back to who put the funds in.
Yes, and that doesn't mean the person who loaned the money. The RAD goes back to the resident who's gone into the nursing care.
That's right.
Yes. Dan, you mentioned there a moment ago about testamentary trusts, and quite often people glaze over a little bit when you talk to them about testamentary trusts initially because they think that they're a highly complex thing. But although it is a more complex will, it is a very, very useful estate planning tool.
Yeah, well, I would say out of the options we've discussed, this is probably the best one because it provides you with the greatest range of flexibility to adapt over time. And it provides you with options of, first of all, tax planning, which is obviously not as strong of a consideration, but also to provide for not just the spouse but also the children at any point in time, because there can be provision made for the children during the lifetime of the spouse as well. The key thing around the testamentary trust is who's going to be controlling it. If we don't have the right parties in control, the plan can be undone, or one of the parties could be getting treated adverse to what you intended. So that's the key discussion that needs to be had. There's also other things such as talking about land tax and, again, how the assets are held, because if you've set up a trust and there's no assets that are in your name, it's not really going to work. So we also find that it's good at avoiding that repartnering risk because you can exclude spouses as beneficiaries. So the assets stay within the trust, and it's only providing for your surviving spouse and your direct descendants. So I find it's a very useful tool. There's also things such as you can change the terms of the trust during the lifetime of the trust, and you can do things such as making loans, which ultimately will come back into the trust at some point in time as a protective measure.
And of course that issue about being able to vary the trust while it's operating, so that's after the death of the person whose will has set the trust up, it's important that there is a provision in there that allows for variation, because if there is no variation provision in the will or in the schedule for the trust, then it can't be done.
That's right, because it's not just the lives of the people involved that change, it's also the legislation and the climate around that's also need to be taken into account. Yes.
Well, look, unfortunately, Dan, we've run out of time. We haven't run out of topic because I know there are a couple of other points there that you were going to talk about, but we might leave them for another time. So, Dan O'Connor from Bell Legal Group, thanks very much for being with me today for The Law and You. I'm John Fradgley. I'll look forward to being back with you again next week for another program of The Law and You. But as always, until then, it's goodbye and God bless.